This is OCCN 2020.
Welcome to Conversations with Candidates, sponsored by the Oberlin Community Candidates Night Planning Committee. My name is the Reverend David T. Hill, and I'm not only a resident of Oberlin, but I've served for the past 17 years as the pastor of the First Church in Oberlin, United Church of Christ. First Church has hosted the Oberlin Community Candidates Night for many years, and I am delighted to have been invited to serve as a moderator for a couple of these Zoom sessions. Joining me is Allison Ricker, who is the co-chair of Oberlin Community Candidates Night Committee, and candidates for Judge, Court of Appeals, 9th District, Julie Schafer and Betty Sutton. Before we get started, I want to mention a very useful resource of information on these candidates. Judicial Votes Count. You can find the site easily with a search in Google. We will begin with 2-minute statements from each candidate, beginning with Ms. Schafer, and then move into questions from the Oberlin Community Candidates Committee and those submitted by community members. Candidates will have 10 minutes each to answer questions, followed by 3 minutes each for any follow-up or responses to each other. So, Ms. Schafer, please begin.
Thank you for the opportunity to be here today. I wanted to let you know that my interest in pursuing a judicial career began in 2012 when I became concerned that many persons of power and authority in all branches of our government seem to be overstepping the bounds of the Constitution. I firmly believe that adhering to our laws as written and amended and our judicial precedent as applied keep this country on a firm foundation. While the authority for changing statutes and laws belongs to the legislative branch, individuals in the other branches who seem to be unhappy with the slow process of political sausage making have become more bold in going in a due direction with no lawful authority to do so. My philosophy of the judicial role is that the judiciary is to apply the laws as promulgated by the legislative branch and enforced by the executive branch of our governments. Congress has been charged with the duty to make laws. Judges apply the laws based on plain meaning and past precedent. The stability of our families, businesses, and our general welfare depends on the consistent application of our laws, and sometimes those laws have unintended consequences. When that happens, it's the duty of the courts to call it to the attention of the legislature so they can work to correct the language. The greatest challenge to judges that I see is the temptation to fix things that aren't in our wheelhouse to fix, also known as judicial restraint. What makes me stand out as a judicial candidate is I'm the only one who actually has real-life practical experience of all the kinds of cases that come before the Court of Appeals. As a private practice attorney for over 12 years, I interacted daily with domestic relations, juvenile, probate, and civil litigation in our trial courts. In fact, I'm the only judge of the 9th District Court of Appeals who focused on these kinds of cases exclusively. As a municipal court judge, I've heard misdemeanor, criminal, civil, and traffic cases. And then as appellate judge, I've obviously heard all the cases that come before our court for the past 5.5 years. Further, in response to COVID-19, the Supreme Court of Ohio has told filing deadlines from April until July 30th. Now that our trial courts are scheduling and hearing trials again, a glut of those appeals are going to start to come before the 9th District later this year and well into next year. Re-electing me will keep those cases on track and not result in any delays, bringing stability and finality to those folks in uncertain times. Another reason is because I'm the only judge that doesn't reside in Summit County. Our jurisdiction covers Summit, Lorain, Medina, and Wayne counties, over 1.2 million residents. If you value diversity, then at least one of our judges should come from a county other than Summit. Thank you.
Thank you. And Ms. Sutton.
Thank you so much for having me. I'm Betty Sutton, and I want to serve on the 9th District Court of Appeals because I know it's crucial that our court be fair and impartial. And having worked as a lawyer, been a lawyer for nearly 30 years, as well as working as a lawmaker and an executive, has given me unique insight into the law from the various perspectives and how it should be interpreted, and a deep understanding of the importance of fairness and justice for everyone who comes before the court. You know, as an attorney for nearly 30 years, I have represented people throughout Lorain County and beyond in the 9th District. I have stood with parents who are looking out for their children, and for people, stood up in cases for people who have been injured through no fault of their own. And I have also focused on representing workers, firefighters, and teachers and nurses, those who haven't always been fairly treated, fighting to make sure that their rights were protected under the law. That's the kind of experience I will bring from private practice. Again, also working at least 12 years, and I believe beyond in private practice. I want to make sure that we get that out there. Beyond that, though, I also have other additional experience that is unique that would benefit the court as a whole. The court is a panel of judges, and we've got 4 who are sitting there with judicial experience. But we don't have any who come with the experience that of the wide array of subjects that I have engaged in through my life. I have served on the Barberton City Council. I was elected while still in law school. I went to law school in Akron, where I was recognized for excellence in constitutional law. So I too believe in the value of our Constitution, the interpretation of our laws. And I have the experience as a lawyer, a lawmaker, congresswoman, state representative to bring to that court extra value. Thank you.
Thank you both. So we'll move into our question period. And the first question that I'm going to ask each of you is, which judge do you most admire and why? So we'll start with you, Ms. Schafer. Which judge do you most admire and why?
Any judge in general?
Yep, and it just says which judge.
Which judge? Well, it's hard to give you the name of a judge. I can tell you the characteristics of the judges that I admire the most. And I guess primarily those would be those who are able to maintain judicial restraint on the bench, who don't overstep their bounds, as I said earlier in my introduction, and who enforce the rule of law as it's applied and don't overstep it. I prefer judges who can sit on the bench and maintain a face of decorum and stability and provide confidence in the people that come before the court, that they know they're going to be heard and they're going to be treated fairly and they're going to be treated justly. There's a number of judges that can do that from all political parties and from all backgrounds. So I think it's the characteristics that the judges have in particular, rather than just one person. They're not all embodied in any one person. They're characteristics that come all across the board.
Thank you. And Ms. Sutton, what judge do you most admire and why?
Yeah, there are many judges I admire as well, but I will settle on Florence Ellenwood Allen, who was a judge out of Cuyahoga County, who became the first woman to serve on a Supreme Court, a court of the highest order in any state in the nation. She was a woman of supreme independence. In fact, ran as an independent, would not accept the help from either the Republican or the Democratic Party when she sought election. She broke a lot of barriers, but she was also an amazing jurist. And her opinions are well thought out and certainly adhering to the analysis and application of the law in a way that I greatly admire.
Thank you. Moving to the next question, I'm going to switch the order just to try and keep things even. What issues facing the Court of Appeals in terms of either procedure or the nature of cases brought to the court concern you, and how do you propose to address them? We'll start with you, Ms. Sutton.
Thank you. Well, I am concerned about ensuring the timeliness of decisions, making sure that people get the decisions based on the merits of the final appealable orders. There's a lot of bouncing around that seems to go on, where people take an appeal to the Court of Appeals and then have to brief whether or not it is a final appealable order, all of that adding to the expense for litigants, as well as delay in process. Now, sometimes it can't be avoided because not every case is created equal, but I do think improvements can be made. I also think working to add greater transparency to the court. Certainly the court is now allowing for people to witness the court in action, but I think it would also be good for people to be able to track where the cases are after the proceedings occur. It's also vitally important that judges are prepared, that they are no rubber stamp for just decisions that come up from the lower courts. They do come up from a variety of areas and on a variety of errors. And I do believe the wide array of cases that I have dealt with, both as an attorney a lawmaker and an executive. I worked in the Obama administration as the administrator of the St. Lawrence Seaway, where I dealt with a lot of complex issues to keep the seaway open and American families working. So I think that are a myriad of things that we can do to improve efficiency and administration. But I also think there is a calling to be a part of the solution at this point when we are looking at potential biases that may exist within individuals and our system of justice. And I look forward to working on those areas as well, with the Chief Justice of the Supreme Court, Maureen O'Connor, in the lead.
Thank you. And Ms. Schafer, your response.
Well, I guess I'd have to say that our court has been instrumental in a lot of improvements in the state. We tend to be on the cutting edge of a lot of different things that the courts of appeals are putting in application. Certainly, we're one of the first putting hearings on YouTube. All of our arguments have been on YouTube for a number of years. Adding the Zoom aspect of it now with the COVID has really made a big difference as well. I think more people are watching, which is nice, but our court is not, it's not a trial court. We don't get a lot of people who come to our court. We hardly ever see anybody. We have two attorneys generally who argue, and sometimes most times the parties don't even show up. It's hard to be more transparent when there's nobody there if they need to show up. I think Zoom has done a lot to help that. So there are some unintended consequences of the COVID virus, and this might be one of them. I think one of the problems that we have is that a lot of people expect our court to fix things that the trial court did wrong or that wasn't argued at the trial court. And we don't have the authority to do that. We don't have the authority to address non-final appealable orders. So unless all the issues have been addressed at the trial court level, we are not going to be looking at them. They need to go back to the trial court to put an entry on the final order that we can go back and look at. And then sometimes that's really aggravating because it does need to be addressed. It does tend to take things longer, but that's the way things go. So I think part of the biggest problem we have is educating not only our trial courts, but our trial attorneys so that they know what's coming before the court. We regularly have seminars where we invite the attorneys to come and we address the educational issues that they need to talk about. So I think that's important too. We also are improving our court by a new case management system. The Supreme Court has adopted a new case management system for the appellate courts so that we can keep better track of where our cases are in the stream. Sometimes things happen when we go in and we conference, and generally we agree, but as we work through the case and we compare the rules to what's going on, sometimes these cases need to flip and it takes a little bit longer. So I think generally we're doing well. We're usually one of the busiest courts in the state, and I think we're doing a great job of it. I'd like to keep that going on.
Thank you. Again, flipping the order, we are moving into a section of specific questions to each of you. So I'll start with a question to Ms. Schafer. How often have you written separate opinions, either dissents or concurrences? When do you write separately?
Specifically the number, I don't really know. A dozen over the past 5 years. Generally, what happens when we conference, a draft may come around to us and we may disagree with a part of the draft, not enough to dissent on the case, but certainly enough to have a discussion with the other judges and talk about, where we're differing on this. And we try to work it out to come up with an opinion that the court can issue that we all can stand on. I will dissent on a case, or I will concur in judgment only if I have issues that are not being addressed by the other two judges on the case. It's like being on the school board again. I was on the school board for 14 years. It's a panel and we need 2/3 to get an opinion out. So I will write a dissent if I feel strongly that we're going in the wrong direction or this is not interpreted properly, and that there's other case law that will support that. So generally it's not too often because we try to discuss this. As I said, it's a panel and we do conference on these things. So that's pretty much how we do it.
Thank you. Ms. Sutton, here's a question directed specifically to you. Why should we replace an incumbent judge? What would you do differently than Judge Schafer?
Thank you for the question. I believe I bring a myriad of experience that is not presently on the court. As I mentioned in my opening, it is a panel and there are 4 other judges there. Obviously, they have experience being on the court, but I have experience of seeing the law from a variety of different angles. It doesn't mean that I want to go onto the court and legislate. I certainly do not. I want to be a judge, and I believe in the oath of office that I took for those offices, and I will believe in the oath of office and our Constitution as I raise my hand if given the opportunity to serve here, to adhere to the call of the judiciary. But I do think that the wide array of things that I have been exposed to, I have chaired hearings, I have asked questions, I have been engaged in the law my whole life, both as a practitioner in private practice, as well as an elected official in other capacities. I have unique insight that I think will add value to the court that is important. And when combined with those who already sit there, will just make our court all the stronger to deliver justice and fairness to everyone who comes before it.
Thank you. Returning to Ms. Schafer, how often do your decisions, whether you wrote the opinion or were on the panel and joined an opinion by a colleague, get reversed by the Ohio Supreme Court?
Not very often. The Supreme Court really only hears about 100 cases a year. I think I can think of 2 or 3 of the ones. I have 2 up there right now, I believe. One had already been denied cert, and then it was reopened for another reason. I had a case that was reversed because the lodestar was miscalculated on attorney fees. That was a simple thing, then the law changed. That's why the case got changed. It's not very often at all that we get reversed from the Supreme Court. I think our decisions are sound, our opinions are well researched, and we do a really good job of presenting that information to the court. And I got to say, occasionally there are cases that need to go to the Supreme Court because there's statewide implications that the Supreme Court needs to make a decision for all 12 appellate districts. And so sometimes you're happy that those cases going up there because they need to address this for everybody. So I don't always feel bad that they end up getting appealed because, like, as I said, that's the Supreme Court is the supreme statement for the state. And I agree that they need to be the ones to make some of these decisions.
Thank you. And a second specific question to Ms. Sutton. You have never been a judge. What will you bring to the bench that will allow you to do the job well from the first day?
Well, I appreciate that question. I haven't been a judge. That's the one area of experience I will not bring under the law. I have, however, worked in private practice, and that experience is valuable and important. I have worked in criminal matters as well as civil matters and administrative law matters. As a member of the Ohio House of Representatives and the United States Congress, I served on the judiciary committees where I learned to write the laws and oversee the courts. I was always and have always been engaged in the law. While serving in the Ohio House of Representatives, I worked with then Justice Alice Roby Resnick to increase access to legal help for women. I served as the chair of the Women in Law Committee of the Women's Policy and Research Commission. So my experience in the legislature is not just about being a legislator. It was always squarely aimed at the law. And I believe that with seeing it from those angles, as well as my service on the St. Lawrence Seaway Development Corporation, where I dealt with many complex legal matters, including bilateral trade relationships with Canada, state interplay of law under and federal law under the Clean Water Act or the Invasive Species Act. The St. Lawrence Seaway is bordered by 8 states, 2 provinces, a lot of local governments, tribal governments, and 2 nations. There are a lot of complex legal issues that come to bear. And all of that, the myriad of experiences that I have, I believe will help me add value to the court and do a good job in each case.
Thank you. So again, switching up the order, now we're at one more common question to both of you. So we'll start with Ms. Sutton. Do you support making Judge Jennifer Brunner's set of rules for juries to ask questions a statewide protocol?
Well, I am not really familiar with each and every item that Jennifer has proposed, but I think we should always be looking at ways that enhance the administration of justice. So that would be the criteria through which I would evaluate whether or not, it's a good idea. Now, of course, at the Court of Appeals, we do not review or we do not have juries. So it's a matter of application of the law and questions of law, not of fact at that level. So I think that whenever anybody is working to enhance the administration of justice, fairness in our courts, improve the situation, it's worthy of a look and thoughtful consideration.
Thank you. And Ms. Schafer, your response?
Well, I know that some courts, some trial judges already permit jurors to ask questions. Frequently, they'll have them write questions and pass them up on papers that the court itself can ask, rather than the individual juror is identified as the person asking the questions. But the trial judges have that authority to already permit jurors to ask questions if they want to. So it's rather making it every judge has to do that. Some cases you don't really need that. In some cases you do and you want the input. So I think the attorneys that are arguing the case, and certainly the clients themselves, ought to have that option. So I don't know that it doesn't already exist.
Thank you. So moving into sort of the concluding portion of our conversation this afternoon, this is the opportunity for each of you to have 3 minutes for follow-up or particular response to your opponent. So we'll start with you, Ms. Sutton, if you would like to take a few moments for any follow-up or response.
Well, thank you so very, very much. Again, I am running for the Court of Appeals because I am very concerned about making sure that everybody who comes before the court is treated with fairness and receives justice. The Court of Appeals is sometimes overlooked, and as my opponent said, the Supreme Court doesn't hear a lot of cases in the scheme of things. And so the court of last resort is the Court of Appeals. And it makes profound decisions that impact people's lives and our communities in very, very significant ways. I understand this deeply from every angle. And all of the experience that I bring together, the conglomerate of work, having been an attorney for 30 years, having worked as a lawmaker as well as an executive, all of that combined, I believe, would add value to the work of the court, and in combination with those who are already sitting there as a judge. It's true that I am not a judge as of this moment. But with that said, I also know that my life is a testament to the fact that I will do the hard work that is necessary to do a good job and pursue excellence in every single case that comes before me. It is vitally important that judges are diligent and prepared, that if they have a concern about a case, they ask the question during the hearing. This is a complaint that I hear from practitioners, that they ask a question to identify that concern that they may have going in there, or why they think the case is going to turn in one direction or another. And obviously, it's not determined beforehand, but maybe there's a concern. And so that if you raise it, you give the attorney for that party the chance to address it. That's all very, very important in ensuring justice, because it's the end of the line for most cases that come before the Court of Appeals. And I just believe that my fundamental understanding and dedication to fairness and justice, a fiercely impartial judiciary and an independent judiciary, is supported by the evidence. You know, judges like evidence, lawyers like evidence, and the work of my life. And if I am given the opportunity to use what I have learned through the years, I will work every day to bring that unique value to ensure that everyone who comes before that court receives the fairness and the justice that they deserve. I respectfully ask for people's vote.
Thank you. And Ms. Schafer, your closing comments or follow-up or response?
I have to say that in my experience as an attorney, my experiences on the bench, I don't know how much executive and legislative experience would help. Most of the cases that we hear, 40% of them are criminal cases, and those are appeals for various and sundry reasons that are brought to the attention of the court by the trial attorneys. 25% of our cases are domestic, juvenile, and probate cases, and those are child support, those are domestic violence cases, those are termination of parental rights for juveniles. These are things that are everyday law that we experience every day in our lives that come down to just the people that are standing before our court. There are the civil cases that we come, a lot of these are civil cases from between businesses and neighbors. We don't have the kind of broad reaching types of cases. Every once in a while we'll get one, but by and large, these are the daily things that every one of us live with. And those are the things that I've had experience with over my career as a lawyer, and also my career in the private sector as well. Having been a foster parent for 15 years, I understand completely what happens in our juvenile courts with termination of parental rights and what happens with our juveniles. In probate courts, we deal every day with probate courts, with will contests and guardianship contests. And so again, in domestic relations court, we hear a lot of those cases, and a lot of that stuff has to do with the civil things that come before our court as well. So a lot of these big issue things are things that we learn in continuing legal education, which help bring some wisdom to the bench and help you look at these cases with a bigger scope. But these cases are our neighbors. These people are us. These people are the things that we need to have taken care of in our lives so that we can live a safe, stable future and be confident that our cases are going to be heard. And as far as being fair and impartial, that's what I've been doing. Like I said, for 15 years, I've been a foster parent. I never asked who's coming into my house. Midnight, they'll call, I'll take whatever comes, and I don't care. I was on the school board for 14 years, making sure that the equal opportunity for education for every single student that comes to our district. And so I think I've been that voice for minorities and the voice for fairness and impartiality for the past, since 97 when I first got on the school board. So I think I am. For over 20 years, you've trusted me to protect your money, your schools, your children, and your rights. You're still safer with Schafer.
Thank you both for participating in this conversation today. I'm sure this will be immensely helpful to folks as they go out to vote, and I appreciate your time and your willingness to share your background and your experience. Thank you both so much.
Thank you.
Thank you for the chance to be here today.
Thank you for watching. The OCCN has been a nonpartisan collaboration for more than 25 years. Here are the 10 organizations who have worked together this year. We thank them all.